In this installment of Washington Legal Foundation's Legally Brief, Stephen Kowal, a partner in the Chicago office of the law firm K&L Gates, will discuss vicarious corporate criminal liability, an issue on which he wrote for Washington Legal Foundation's Legal Backgrounders series, which is available on Washington Legal Foundation's website.
Thank you. During the last decade or so, the government has significantly increased its focus on the criminal investigation and prosecution of companies. This has exposed what I believe is a very substantial problem. Under the law that imposes criminal liability, companies are subject to prosecution for conduct by employees that is neither authorized nor condoned, and which in fact the company had specifically prohibited. This seemingly bizarre situation distorts traditional theories of criminal liability, imposes crippling penalties on many innocent third parties, and affords the government enormous advantages the government has learned to exploit. This situation stems from the application of a decision by the U.S. Supreme Court in 1909. The court held that a company could be vicariously liable for the acts of employees so long as the conduct was intended to benefit the company and the employees acted within the scope of their authority. Over the years, the expansion of the Supreme Court's holding has been breathtaking. Courts have held it is only necessary that some aspect of the employee's conduct was motivated by a decision to benefit the company. There is no need that the company actually received a benefit or that such a benefit is even a realistic possibility. Also, the requirement that the employee function as an agent of the company has been given a broad reading. It is only necessary that a third party reasonably concluded the conduct was authorized, even if the company had provided no such authorization in fact. Unquestionably, this exceedingly broad legal theory has accorded the government enormous discretion in deciding whether to prosecute, and the government has exploited that power. Few companies can withstand an indictment, even if they were to prevail at trial. By that point, the legal victory may be very hollow. Just ask the former employees of Arthur Andersen. The need to attempt to avoid indictment through a demonstration of cooperation is the basis for the corporate decision to waive the attorney-client privilege, the refusal to indemnify officers and employees, and the avoidance of joint defense agreements. I suggest that this situation needs to be addressed and some balance restored. This can be done by according corporate compliance programs the recognition they deserve. Companies cannot absolutely control the conduct of each and every employee. The most that can be done is to formulate policies and programs that require adherence to legal and ethical standards, to effectively communicate those policies, and to diligently monitor compliance. With such a program, the company has done everything in its power to avoid misconduct. It has met the traditional test to avoid criminal liability. If an internal compliance program meets objective standards of reasonableness and effectiveness, it should shield the company from prosecution. The company should not be required to do what is impossible, that is, absolutely control the conduct in each and every one of its employees. In the face of this type of program, there is no legitimate basis to prosecute the company. The traditional goals of such a prosecution have already been accomplished. Specific deterrence will not be enhanced because the company has already done everything reasonably expected. General deterrence will not be promoted, and may be undermined, by prosecution of a company despite its best efforts to secure legal compliance. This type of recognition for a corporate compliance program will not allow the misconduct to go unpunished. The culpable employees are still subject to prosecution. Also, victims will be able to seek restitution through traditional civil procedures. But such an approach will produce several significant benefits. It will reflect the reality of the company's ability to control the conduct of employees. The company can set policies, but it cannot impose absolute control. Also, such an approach will help avoid the crippling hardships that are imposed on many third parties by corporate prosecution. Often, the staggering penalties imposed are borne by shareholders and executives who played no part in the offensive conduct. Importantly, such an approach would help to reduce the government's enormous discretion and restrain the erosion of the rights designed to protect those confronted by government criminal investigations. In sum, I suggest it is certainly time to credit the importance of corporate compliance programs and view them as a legal shield against corporate criminal liability. Thank you.